Hey everybody, Kartik Subramaniam over at ADHI Schools. Welcome to your real estate tip of the week. The legal presumption is that all property acquired during marriage by a husband and wife generally would be considered community property. So if two spouses buy a piece of real estate together, generally that's considered community property, meaning that half is owned by one spouse and half is owned by the other spouse. Now, that could be a same-sex couple or it could be a heterosexual couple, but either way, in California, the legal presumption is that property acquired during marriage is considered a community property and is owned 50-50 by either spouse. Now, there's some exceptions to this. For example, you could have property being given to you by gift if you're married. Generally, properties given to you by gift are considered separate property that you get through inheritance. And there's other exceptions too, but generally and broadly, the legal presumption is that property owned by two spouses and acquired by two spouses during marriage would generally be considered community property in California.